Good afternoon, everybody. Welcome to Stewarts Soundbites. I feel like I haven't done a Stewarts Soundbites in ages, so I'm a bit out of practice, so bear with me. But I am put at ease today because I'm joined by Ben Townsend. Hello, Ben.
Hello.
Everyone who's watching will probably know who you are, but Ben's a partner in the personal injury department at Stewarts in Leeds. Ben's also my supervisor and probably the most enthusiastic and formidable opponent you'll ever come across in a karaoke showdown. But today we're putting our serious hats on for a little while, Ben, because we're talking today about documents, which are king in our world. Producing them, sharing them, how to report effectively, and all of this stuff is going to be aimed primarily at case managers and rehab professionals. That's not to say that there won't be something of interest for everyone. So I wanted to start off, Ben. I'm just going to jump in because we don't have enough time, as always. So we all know how important documents are in litigation cases, particularly these catastrophic cases that we deal with. What are the key things that lawyers want to see in case managers' reports and documents, any therapy updates, and do you have any tips on what to avoid?
Yeah, I mean, as you say, documentation is absolutely key. We need to show to the court, ultimately, to the judge, what a difference the rehab professionals and the case manager are making to the life of the claimant. So it's really important that they record all the problems that they see. They need to record the progress that they're making. What are they aiming towards with the interventions that they're making with the client? These are absolutely vital to have. It's important that, particularly with support workers, that they record the things that they do support the client with, because we need to show to the court ultimately that the support workers aren't just paid mates hanging around and having a chat with the claimant. They're there to fulfill a purpose, and the documentation that is produced by them, as well as the other rehab professionals involved with the client, are absolutely key for us. So it's really important that they're done well and they're done thoroughly.
Yeah, and I always think that real life examples are so helpful, illustrations of a problem, rather than just saying, there are problems with memory. It's really good to say, on these days, these were the problems. I find that that's helpful.
Yeah, absolutely.
And pretty persuasive. I want to talk briefly, if we can make it brief, about privilege, because it is a tricky area, actually, and it can be quite confusing, and it's also to an extent subjective. But can you just outline briefly, Ben, the types of privilege, how to identify whether a document is privileged, and how important that is for case managers and for rehab professionals to be aware of?
Well, in brief, you need to really leave privilege for the lawyer to worry about. But let me tell you, or the audience, about a number of different types of privilege that are available. The ones that you're going to, the lawyer's going to come across in the context of this sort of litigation anyway. The first thing to mention is without prejudice communications. Now, some people think that if they write without prejudice on a letter, that means that it can't be shown to anybody else, and that just isn't correct. Without prejudice communications have a specific role in litigation for to allow negotiations to take place between the two different parties. So if the case manager writes an email to you headed without prejudice, that in itself doesn't have an effect. The main types of privilege that are going to be important in the case, the types of legal professional privilege. The first one is legal advice privilege. Now, those are communications between a client and their lawyer for the purpose of giving or receiving legal advice. The second one is litigation privilege, and those are communications between a lawyer or a client and a third party, again, with the dominant purpose being the litigation. Now, those different types of privilege are for the lawyer to worry about in the context of case management, rehabilitation document, but there will be bits and pieces in there that the lawyer needs to redact. But ultimately, just leave the lawyer to worry about which parts of the documentation are privileged. If there is a part that a case manager feels is privileged in that way, there's no harm in writing privileged upon it, and that may concentrate the lawyer's mind on a particular communication, but ultimately it's the lawyer's decision as to where the client's privilege lies.
Yeah, and I suppose if you're singly instructed case manager, you can always lift the phone to your solicitor, can't you, if you're worried about sticking something in?
Yeah, you can if you're singly instructed. Jointly instructed, there's no back door. Everything has to go to both parties.
Yeah, I'm
afraid. But yes, singly instructed, you have that luxury.
Yeah. I wanted to talk a wee bit about sharing documents, because this is a really common problem. It's can be a sticky issue because there'll always be documents floating around in the litigation that case managers or rehab professionals are keen to share and need to share. How does a case manager or a treating clinician rehab professional know whether they can share a document with another member of the MDT? When is it appropriate for them to do so?
I think the first thing to mention are expert reports from the litigation, which can find their way out to people without the lawyer necessarily knowing about it. The client might have passed one to you without telling the lawyer that that's what they've done. If you have anything from the case that you have, you should always ask the lawyer before you pass it to anyone. That expert report may still need to remain confidential. So always ask about anything like that. With reports from rehab professionals, it's well worth speaking to the lawyer before they're distributed, but they're generally less of a problem. They're generally not going to contain privileged material. Records from the rehab professionals, again, they may be less usually distributed around the rehab team, but the lawyer will probably want to have a look at them before they're distributed. So generally speaking, just speak to your lawyer before you send things around different people. The immediate needs assessment is in a case in point, because if the immediate needs assessment, the initial assessment by the case manager is produced under the rehabilitation protocol, then unless both parties have agreed to its release, then it can't be referred to anywhere else. So again, it's worth checking with your lawyer before even a document as potentially innocuous as the INA is sent to anybody else.
Yeah. That's super helpful. And one of the things that you mentioned there, Ben, is the expert reports, which I just wanted to elaborate on very, very slightly. And sometimes it's not necessarily that you have an expert report and that you're going to distribute it or anything, but it's that maybe, as a lawyer, we've said to a case manager, the expert has recommended these things for the client in his or her report, and can you follow up on these treatment recommendations? Sometimes it's difficult. It's not necessarily the reports themselves from experts, but it's references to reports in treating records, daily notes or other reports. It's a reference to the reports themselves within those notes. So how much of a problem is that? And is there any way that we can get around it?
First of all, with regard to mention of experts' reports in case management material, records, notes, rehabilitation records, again, it's for the lawyer to consider that and whether privilege is potentially going to apply to documents and redact them before they're sent on elsewhere. Yeah. If the case manager has had a specific recommendation for an intervention that the lawyer has mentioned has come from an expert, it's easiest, if possible, I guess, if the case manager can just say this has been recommended and avoid mentioning where the recommendation has come from. That would be the easiest way to avoid getting in causing issues for the case.
Yeah, that's so helpful. And I just wanted to touch upon these cases that we deal with are complex, and there are often difficult family dynamics, difficulties in the rehab process, sometimes with engagement, loads and loads of, there's a whole range of issues that can crop up. And these type of issues might have a potentially negative effect upon the case, upon value, upon any number of things. And I know that case managers and therapists are often mindful of those negative issues having an impact on the litigation. I was wondering what you think about how those types of issues can be handled in documents, because I think there's often kind of a concern about how they're expressed and what the impact might be.
Yeah. I suppose it depends upon the type of issue, essentially. If it's a problem within the family, and this is a document that the family are going to see, then if there's a prospect that there's going to be damage to the family dynamics, and that's going to affect the rehabilitation that can be provided to the client, that's a tricky issue to get around. And you're going to have to think very carefully about how you handle that. And again, it might be worth speaking to the lawyer about, as a team, how it might be tackled dealing with a particular tricky family dynamic. Yeah. If it's a problem, say, with a client who is not engaging in some way with the rehabilitation program, then that should be recorded. It should be tackled head on. If that's not put in case management material, then that's the sort of issue that's going to come out. And if it's not mentioned in the case management material, it would leave a case manager vulnerable to being criticized in cross-examination. So it's important that it's recorded, and it's important that it's tackled, because these sort of issues can cut both ways. Whilst it's not great that the client isn't engaging with the rehabilitation that they're being offered, on the other hand, that might be, for instance, a sign of their lack of insight, their lack of understanding and appreciation of the problems that they're facing. So essentially, generally speaking, if you've got issues, you need to record them and record how you're dealing with them. And the lawyer should be doing what they can to assist with that.
Yeah, I think sometimes you have those issues and you just think, well, we are, where we are with them, and we just have to figure out how best we're going to get around it. But as you say, being upfront is always a relief and the best thing.
Yes, absolutely.
So this is a question. The next question is one that I was sent in advance, Ben, and it's an interesting one. And it's about how to cost case management work. So can you explain what should be costed as litigation, what should be charged as litigation work by a case manager, and what falls into the other category of supporting the client and doing normal kind of rehabilitation role?
Well, I suspect any lawyers will be shouting at me because they will take a different view on this. But my view is it depends upon the purpose of it. If a lawyer asks a case manager to do a witness statement, for my money, that is a cost of the litigation rather than case management work. If, for instance, though a case manager accompanies a client on an expert appointment, as they often will, that is to provide support to that client, in my view, just as they would for any other important meeting appointment that they might want to attend. So for me, that still falls within the case management remit. So it's about whether it's part of the case management role, or it is separately, specifically only for the litigation that the work is being completed.
Okay. It's kind of, it's a little bit like when we look at a document for privilege, really, isn't it? We're asking ourselves, what is the purpose of this document? What was it created for? Is it for the purposes of litigation, or actually does it just relate to the rehab? And sometimes it's not so clear cut, is it? Is it something generally that you would be happy for a case manager to ask your view upon?
I am always happy for case managers to ask me my view on anything.
Yeah.
So yes.
And we
Yeah,
like
absolutely.
A good chat as well.
Yeah, always happy to have a chat. But yes, ask your lawyer how they want you to deal with charging for a particular piece of work if you're not sure.
Yeah. Okay, well, I think we've done it actually, Ben. I think we've just inside 15 minutes, although I might be completely wrong because I forgot to set my timer, but I do think that we've done pretty well with flying through those questions.
Well, I did my best to keep privilege down to a reasonable amount of time.
I think it's the most succinct summary I've ever heard, so that's kudos to you.
Thank you. It's probably because it was inaccurate, but never mind.
Oh, don't say that. Not at all. Well, thank you ever so much. Ben, that was really insightful and really helpful. And because this is a pre-recorded session, I'm afraid we can't, we don't have any, well, we just won't be there to answer any live questions. So if you do have any questions on the back of this session, please feel free to email me or Ben, and we'll be very happy to come back to you. And the other thing I wanted to mention, which is quite exciting actually, is that the soundbite sessions that we've had previously are all obviously available on our website as webinars, but they've recently been converted into podcast format somehow, which is completely beyond me. But yes, they're now available in a very jazzy podcast format, so you don't necessarily need to be sitting in front of a screen, you know, on your commute, walking the dog, whatever it is. You can download them and listen to them at your leisure. We'll see you again in a couple of weeks' time. Thank you.
Thank you.